We'll find out.
SJC-10744, the Real Estate Bar Association for National versus National Real Estate Financial Services.
Good morning, counsel.
Good morning, Your Honor. May it please the Court. Doug Salveson for the Real Estate Bar Association of Massachusetts, Inc. This appeal presents two questions certified to this Court from the First Circuit concerning the activities of National Real Estate Information Services, a limited partnership based in Pennsylvania. NRICE provides all the services necessary to convey the legal interests in properties located in Massachusetts that secure loans made by mortgage lenders to Massachusetts homeowners. The first question posed by the First Circuit is whether NRICE's activities, either in whole or in part, constitute the unauthorized practice of law. And I submit there can be virtually no doubt that in whole, NRICE is providing a legal service.
So when you say in whole, you don't think it's important, indeed essential, to kind of parse out and look at each of the activities individually?
Well, to answer the question posed by the First Circuit asked in whole or in part. And I think
But you just answered that you think in whole, it's practice of law.
I think there's no question in whole, and the second part of my argument is going to be also in part. Each of the activities, the three constituent parts of a conveyance, constitute the practice of law. But in whole, those activities are the assessment of legal title to the property, whether or not the seller, the mortgagor, actually owns it.
I can't glean from the brief, and I'm sure it's my failing, but the review of documents, who reviews the documents to say, okay, the title is all right, okay, this lien is a minor lien, just put the money in escrow? Who does that review?
The record discloses that that's Conley Title Services, Inc., who NRICE believed was an attorney, a law firm at the time they hired them. They were hired. The testimony from the gentleman who's the director of title services at NRICE says that Conley Title was hired to establish that there is clear title to the property. And that's in the
Okay,
record.
so your answer is that the review of the documents and the determination of whether the title is clear is done by an attorney hired by the defendants.
Well, see, there's the little glitch in this case that's very interesting, because it turns out that Conley Title
I know,
is
but that's
not
just a
lawyer.
red herring. That doesn't
Yes.
change the question and the answer. But they now, is there any fee splitting here? That wasn't mentioned, so I assume there is no issue of fee splitting.
It's not an issue in this appeal, although
Well,
in
how
fact,
how does the defendant make its money?
the defendant makes its money by charging the mortgage lenders for the conveyancing services that they provide, and then
Okay, and who pays these lawyers? Or
NRICE. NRICE pays Conley Title. NRICE pays the lawyers who show up at the closing and record the documents.
and how do the lawyers get on this network?
I don't know that, Your Honor.
Do the lawyers pay a fee to be on the network?
Not to my knowledge. There's nothing in the record to suggest that.
But those are those are the lawyers who do the closing or settlement.
The network of lawyer refers to the lawyers who do the closing.
And then who reviews the documents? I mean, it's a lawyer's business to make sure that this is the document for title and not the document for an adoption. Now, who does that?
As far as we know, it's Conley Title.
Well,
Did-
now, I'm assuming that the closing lawyer has got all the documents there and necessary for the transaction and is going to be ensuring, because that's what lawyers are supposed to do, that all the documentation is available.
Yes, the documentation at the closing is different from the documentation to establish the title.
Right.
There's a title abstract that's created, and there are records as to the title examination. There's no indication that, and it's quite the opposite, there's no indication that any of those records about the title make its way to the lawyer who does the actual closing. So as far as we know, there's actually no lawyer who reviews the title to the properties being conveyed.
When you say no indication, I'm sorry, I mean, has there been discovery in this case? I mean, what,
There's been
is
some...
that because there's no facts development yet?
Well, that requires a short explanation as to the procedural posture of the case. The case was in discovery. There had been some discovery done. There had been depositions taken of a lot of REBA officers. There had been depositions taken of the Director of Title Services and some other people at NRICE. At a certain point, NRICE filed a motion for summary judgment, seeking summary judgment, claiming they were entitled to have the case dismissed on summary judgment because REBA's conception of what conveyancing was not actually the practice of law. And the case was argued to the district court on that basis. So it was all about REBA's conception of conveyancing.
So, all right, now I understand. I mean, I understood that procedural issue, but I didn't know how much information had been gleaned during this process. So let's assume Connolly Title is actually the name of a lawyer, Jim Connolly. And you said NRICE thought they were hiring a law firm. So let's assume it was a law firm. Let's assume Connolly Title did all of the title work and shipped it on to NRICE that then provided it to the attorney they hired to do the closing. What's wrong?
Well, there'd be a lot wrong in that because that in whole would be the practice of law.
And we have two lawyers practicing law.
Hired by a non-lawyer to provide a legal service to a mortgage lender. What they would then be doing...
Can't I hire a couple of different lawyers to do services?
For you.
Yeah.
But you can't hire a lawyer to do a service for me.
Yes, but if just insurance defense work, the insurance company hires the lawyer to defend me when I'm sued, right?
Right. And the insurance company has skin in the game. The insurance company is really hiring a lawyer because their money's at risk. If you are found to be negligent, they have to pay.
Right.
If the insurance company disclaims any coverage, you get to hire the lawyer, they get to pay for it.
Is the question before us really simpler than this? Is the question before us whether or not this type of activity, regardless of who does it, is this type of activity the practice of law?
I think the court could answer the question that way and should answer the question that way because there's no doubt that conveyancing is the practice of law.
But assume that that's what the answer is. Yes, that the work done by Connolly Title is the practice of law, and what the closing attorney does is the practice of law. Just to take back to Justice Cordy, so say tomorrow NRICE says, okay, we're going to hire your firm to be Connolly Title, and somebody else to get those documents. I'm still not clear what would be wrong with that. Because
that is selling legal services, which is really what they do. They hire a lawyer to do the title work. They hire a lawyer to do the closing, who also does the recording.
Okay.
And they reserve to themselves the ministerial back office functions. That's all they do. And they sell that package. So they're selling, the bulk of what they're selling are legal services provided by lawyers. And you can't do that. You can't start a company saying, if you have a lawsuit, come to ABC Corporation and we'll defend you. And the way we'll do it is we'll hire a lawyer who we'll choose, who will be in our network, and we'll provide you with that service.
So you're saying essentially that it's the management of attorneys or the provision of attorneys to other people. That's the problem. It's
interposing an entity, a legal entity that has not gone to law school, that hasn't been credited, that is not certified to be of good moral character, that is not subject to the control of this court or to the BBO, and they're doing everything that a lawyer does.
No, they're not doing what a lawyer does. By your argument, they're getting lawyers to do what a lawyer does. I mean, that's what you just told us. I saw
They're passing those services through to a client. What they're doing is no different from what a law firm does.
So you're saying the law firm would use its associates and they're using you.
Lawyers,
in my example.
exactly. And the court, I mean, you can't do that. You can practice my firm practices as a professional corporation, but all the members of the corporation have to be lawyers. You can practice as an LLC, but you can't have a non-lawyer have an ownership interest.
If one of the components of this service is performed negligently, who does the client bring a malpractice action against?
The client would have to bring a malpractice action against Enrice, because Enrice is the one who contracts.
And Enright is not a lawyer.
No, but
Enrice is
so
not
it
a
would
lawyer.
be, it would be a negligence action.
Yes, they may, if you give the case to a smart lawyer, they may have a claim against the lawyer who actually does the work. I could see them suing the lawyer too, but they have a contract claim and a negligence claim against Enrice.
The way you talk about it, it's as if the lawyer who goes to the closing doesn't really know about the documents or the issues. Suppose there's a lien, an attachment on the property. Who advises the lender about this?
I don't think, there's no evidence that anyone does, but if anyone does it, it would be Conley Title. It would be expected to do it, but Conley Title was deposed, and Conley Title said essentially all we do is create a title abstract. We're not qualified to examine the title and to determine those things.
Well, somebody's providing either a certificate of title or title insurance.
No, well, there's title insurance, but there's no certificate of title in these cases.
Okay.
They acknowledge that the certificate of title that's required under Chapter 9370 is not provided to any of the sales in which they're involved.
And is that the
Let me ask-
responsibility of the lawyer at the closing?
It's responsibility of the lawyer at the closing.
That
representing
lawyer
the
is violating the law?
The lawyer, yes.
Is
Yeah.
that,
The
is that
bottom
the,
line
is that
yes,
the,
but he
the-
cannot certify title because he's not provided with any of the documents.
Let me ask you a hypothetical. Say a person goes to an accounting firm, and the firm says, you've got a legal issue, and we have lawyers here as well. Is there a problem if they then refer the matter to one of the lawyers in their system?
And the lawyer has a direct relationship and is retained directly by that client. There's no problem there.
So you're saying that all the attorneys who have participated in these closings have been violating their responsibilities, their legal responsibilities, because they can't certify title? I'm just asking you.
I don't think there's any way to get around that. I think the lawyer who goes through a closing, knowing about the statute, they put themselves at risk that way, yes.
And the lawyer can't advise the client, the lender, if there's a lien on the property and whether that should stand in the way of the closing?
The lawyer would have no knowledge of that.
He wouldn't have any knowledge, doesn't he get the abstract?
No.
The lawyer doesn't get the abstract at the
No.
closing?
No. The lawyer is basically a notary public who is assigned and paid $75 to go to the closing and notarize documents. That's what the lawyer does.
that's what the
That's
record
all he
shows?
does.
That's what the record shows? Here?
I don't know, I have to say that the dollar figure, I'm not sure.
I don't mean, but I mean, what you just described, forget the dollar figure, that's part of this record.
There's nothing in the record to say that the lawyer actually has any knowledge, and I don't think it's disputed, any knowledge of the title. think
I
that's what the
suppose I
record
can
shows.
believe anything today, but the lenders would go to the closings and wouldn't want to know if there were, and these were quote sophisticated institutions,
They don't go to the closing.
but they don't want to know if there are liens on the property?
Well, I think what the lender is really concerned about is their financial risk.
So if there's a lien on the property, that will affect their financial
But they have
risk.
title insurance. They get title insurance, so that's all they care about. They don't have to
But
live
if they
in the
took
property.
with knowledge of a lien,
They still have title insurance.
Yeah. Now, what does the home buyer get? The home buyer does not get a certificate of title, a copy of the certificate of title to the bank, which is also provided, I think, by statute to the home buyer.
Yes.
They don't get that.
No.
And does the home buyer get the opportunity to purchase title insurance?
Yes, they do.
To cover the purchase price or the mortgage?
To cover
Either, depending on what they're
depending on what
willing
they
to
buy.
pay for.
Right.
Now, you've read, I'm sure, the amicus by the AG.
Yes.
To what extent do you agree with it or disagree with it?
The point that I disagree with is and it's my fault, is the description of recording as not being the practice of law. Recording, the way I described in the brief, is not just limited to delivering documents to the registry, which a messenger can do.
Mm-hmm.
Recording is actually looking at the title record again, up from the time of the initial title examination to the time of the recording, to make sure in that interim of time, whether it's days or weeks, there's been no further problem with the title. And also choosing which documents of the dozens that are signed at the closing, choosing which ones need to be recorded. And that's a legal judgment. So I disagree with the Attorney General's brief to that extent.
Thank you, Counsel.
Thank you.
Morning, Your Honors. My name is Michael Ricciuti. I represent National Real Estate Information Services. With me is Michael DeMarco. I want to go back to Justice Cordy's question because I think it cuts to the heart of this case. We've got to stick with this record. This record, a lot of what my brother has said is not in the record.
We don't have to. We could say, whatever happened in this case, we could say the following constitutes the practice of law in Massachusetts, and these other things do not constitute the practice of law. So we could do that.
Yes, Your Honor.
And then let the First Circuit decide, or the
Correct.
District Court decide where this case falls.
Correct, Your Honor. And in fact, Your Honor, that's where I want to go. I want to deal with the factual issue first so that we're clear what the facts are, because there have been a number of questions. I think it's important. Then I want to deal with the legal issue. From a factual perspective, what happens at the closing was never discovered in discovery. What Henry's business model is that a lawyer is engaged to represent the lender.
And does he answer questions at the closing? Is title good? Is there a lien?
That's an excellent question, Your Honor. That is, the record is completely silent. REBA didn't depose a single one of those lawyers to find out what happened at the closing. REBA did submit an expert affidavit. We challenged whether it was expert, but leave that aside. An affidavit from a real estate practitioner who said at the closing, the lawyer's going to review the deed, review the mortgage, make corrections if corrections need to be made. She said would review the title, review all the documents on behalf of his or her client. There's no record evidence that it didn't happen. The argument that Mr. Salveson was making that...
I'm sorry, did you say that at a deposition somebody said...
This is an affidavit of
An
Kathleen
affidavit.
O'Donnell. It's in the sealed record appendix, Your Honor, and I'm quoting page 30, paragraph 31, as to what happens at the closing.
Right?
The notion that there are no title certifications, which, as Justice Spina noted, is required by statute, there's no evidence in the record that isn't happening. In fact, REBA's... I'm sorry, Your Honor.
Well, there's Kathleen O'Donnell's affidavit about what happens in a closing from her perspective. But are you suggesting that, are you representing that, in fact, the attorneys on N. Rice's list do all the things that she describes
No, Your
should be
Honor.
done?
I'm not representing anything beyond the record. What I'm saying is that Henry's, strike that, REBA proceeds from this notion that a Massachusetts lawyer who's acting ethically and responsibly isn't fulfilling all of their obligations when they're working on behalf of a lender at Henry's request. There's no reason in the record to believe that that is so. There's no reason to believe that title certification in a purchase transaction, which is required, isn't being issued. There's just no evidence.
Is there evidence in the record that the lawyer is paid $75 for this transaction?
I honestly, Your Honor, I've read the record. I don't think that is in the record. There is an amount of money that was quoted at some point. I don't know if it arrives in this record.
Because I was going to say, $75 is not going to exactly cover what Ms. O'Donnell says needs to be done.
Right. Fair point, Your Honor. But the point that I'm trying to make about the record is, confined to the record, the court is just not in a position to conclude that what is happening at the closing table is inappropriate.
Well, let me ask you this. If the attorneys do what the affidavit says they do, which I suppose would be your position, that you would like that, but if they do that, are you then selling legal services provided by attorneys and, as the other counsel says, interposing yourselves as non-attorneys to provide services?
No, Your Honor, and I'm glad you raised the question. There are three cases that this court has decided to help the court make that decision. It's In re McClub, Thibodeau, and In re National Shoe Manufacturers. What those cases stand for is the notion that, and Justice Botsford is quite right, insurers hire lawyers on behalf of clients under Rule 1.8 all the time. What the rule says is, You cannot interfere with the attorney-client relationship or attorney-client communications or the lawyer's independence.
Well, you don't interfere, you do too little maybe, but I'm not accusing you of interfering, but that's the least it
Is
seems
there
to me of your
any
problem.
evidence in the record that the attorneys on this list have any contact at all with the lenders?
There's-
I mean, you assert in your brief that they have a relationship, but I just don't know what's in the record.
The only evidence in the record, Your Honor, came from Ms. Benincasa, who's the head of Title Settlement Services for NREIS, who said that either the lenders contact the lawyers directly and get them the closing documents, or we do. There wasn't a single piece of paper from one of those closings to reflect any communications. But that really is my point. NREIS wouldn't have been involved in those communications. NREIS creates the relationship, but whatever happens between the lawyer and the lender it's just was never discovered.
So let me just follow up. Whoever does whatever, there's a lawyer at the closing, and the lawyer, and money is transferred from buyer to seller, or mortgagee to mortgagor, right? Whatever. I never can get this straight. Yeah, lender to, okay, yeah, lender to borrower, I like that. Okay, so, but who's going to hold that money? The attorney?
It depends on the type of transaction,
Okay,
Your Honor.
well, let's assume it's a transaction where the attorney's holding the money.
Yes.
Okay? So now, if there's any interest, is that going to go to our IOLTA fund?
In a purchase transaction, Your Honor, it would, because the lawyer holds the money. In a refinancing transaction, it may not. It may be held by NREIS and be directly dispersed at the request of the mortgagee.
Doesn't the Attorney General say that there's some statute that says that the lawyer has to do that?
The good fund statute, Your Honor, but that's actually not what the statute says. The statute says that the mortgage cannot be recorded until the mortgagee has released the funds to the mortgagor, the mortgagor's lawyer, or the mortgagee's lawyer. There's no requirement in that statute that the money flow through the IOLTA account. But just to address that concern, NREIS has been in business in Massachusetts since 2002. These companies have been around for 25 years. We're arguing that the status quo be maintained. We're not saying that the IOLTA accounts are going to change tomorrow if NREIS prevails. We've been in this market for a long time. So that
Who reviews these documents?
Your Honor,
I mean, you keep saying we review documents, but who makes sure that the documents are signed in the right places, that the document itself is the proper one? Who does that?
There's two types of lawyers in this case, Your Honor. There isn't a lack of lawyers. There's maybe too many. First, there is the lawyer at the closing table. The lawyer at the closing is going to, if we credit the affidavit, is going to review the documents. It's going to do what a lawyer needs to do to properly close a loan. That's what that lawyer is going to do. In addition, and there's record evidence to this, there are lawyers for the title insurer and the lender. And depending on the issue, those lawyers might get involved as well. For instance, if there's an issue with issuing the title insurance, the title insurer's Massachusetts qualified lawyer will deal with it. So there isn't a lack of lawyering in the case. What Reba is really complaining about is there isn't one lawyer who oversees everything. And that gets back to, Your Honor, to what the definition of the practice of law is.
Wait a minute. You say there's an attorney for the title insurer. He or she comes to the closing.
Oh, no, Your Honor. No. The record evidence is when there are particular issues with title, NREIS does not make a legal judgment.
Okay, but who decides if there's an issue with title? You said, I mean, from my reading of it, you said you just pick some lawyer from your network and tell him the time and the date of the closing, and he goes. But meanwhile, who decides if there's an issue with the title?
Your Honor, if you look at the way the process works, NREIS is going to follow the guidance given to it by the title insurer. If something, and this is Mr. Lemert's.
Who decides if there is an issue? You say NREIS is going to follow what comes from the title insurer. The title insurer sends you some stuff.
Mm-hmm. If there's an issue, Your Honor, NREIS might flag an issue that they can't resolve and leave it to the title insurer's lawyers to figure out.
But then NREIS reviews the document and flags an issue, uses legal judgment, then it's using legal judgment, because how does it know it's an issue?
Your Honor, I don't think that it necessarily is making a legal judgment. If it encounters a problem that its guidance that it gets from the title insurer doesn't cover, it's going to push that to the legal.
No, yes it does, because you have to know the law and you have to know the facts in order to make a judgment that this is an issue. If I took Joe Smith off the street and he looked at some title abstract, he wouldn't know what is an issue in the title abstract.
I understand the question, Your Honor. What I'm saying is that to the extent that the title abstract raises something that NREIS isn't familiar with, be it a legal issue or something else, they're going to front that to the insurer for resolution. NREIS just doesn't make the call.
Yes, but you you look at the documents and you decide this is a problem, I've got to do something about it. That sounds like the practice of law.
Your Honor, but that, to the extent that all ENRI's would be doing is looking for issues that aren't within the guidance that it's already been given by the title insurer, it assumes that flagging of issue is the practice of law. And ENRI's would say, we're just flagging issues, we don't know what they are.
But do you agree that under Chapter 93, Section 70, there must be an attorney for the lender who is certifying that there is good title?
Yes.
And who's doing that?
The closing attorney, Your Honor.
The closing attorney, based on, but apparently there's no abstract before the closing attorney.
And that goes back to the issue, Your Honor, that there's no evidence in the record as to what the closing attorney actually receives and actually does.
Okay, so what you're saying then is we can't answer the question, which the First Circuit says, based on the record in this case, you're saying there is no record in this case.
That's what I'm saying, Your Honor.
So
Exactly.
we should say to the First Circuit, sorry, there is no record on which we can make this judgment.
Responsibly, Your Honor, we've combed through the record. There are a number of issues that shouldn't be resolved
But you
on
moved for
presumption.
summary judgment, so how did you properly move for summary judgment?
That's an excellent question, Your Honor. At the time we moved for summary judgment, Reba had made the argument that every step in a conveyance, we call this the unitary theory, must be overseen by a lawyer. We thought that was too broad in light of this Court's decisions going back to opinion of the justices from 1935, where this Court parsed out what steps are the practice of law and what steps weren't. When we moved for summary judgment, we said that grand theory can't be the law. That's on the basis on which we prevailed on summary judgment. The case now has morphed. We went from looking at the entire process as a single act to looking at it in pieces, and quite candidly, that wasn't how the case was discovered below or analyzed below. And when we went through the record, and I have to be candid with the Court, there are a number of questions that the Court is looking for factual answers, and the record doesn't provide them because it wasn't.
But do you at least agree, regardless of the record, that there must be an attorney in order who is certifying title at the time of recording, an attorney for the lender, to comply with Chapter 93, Section 70?
Yes, Your Honor.
And do you agree that under Chapter 183, Section 63B, there must be the lender must transfer funds to its attorney or to the mortgagor or to the mortgagor's attorney?
Yeah, the statute says the mortgagee must cause that transfer to happen. Yes, Your Honor.
But it must be done either directly or through the attorney for the lender.
Correct, Your Honor.
So there has to be an attorney involved, at least with regard to two stages.
At least with regard to the certification, Your Honor, there's no question. Technically, under the good fund statute, a lawyer wouldn't necessarily be involved, but it's certainly contemplated.
Okay, and there also must be a lawyer at closing.
Henry says never contested there shouldn't be one, Your Honor.
So the lawyer at least needs to do at least three things, and you agree with that?
We agree that, Your Honor, the lawyer must certify. The lawyer can receive the funds. With respect, and I don't want to quibble, but I want to be clear.
But a lawyer, when required by the good fund statute, a lawyer must
Correct.
play his or her role.
Correct, Your Honor. And then we get to the closing, and I go back to the record evidence. We would argue that this Court, most recently in Chimco, has parsed out exactly what the practice of law means, and we would submit it means the exercise of legal judgment or the dispensation of legal advice. The parties have assumed, because it's part of Henry's model, that that's what happens at the closing. Henry's has never conceded that that's what happens at the closing, because there's no evidence of what happens at the closing table. But what was challenged in this case was Henry's business model, which included engaging a lawyer to do whatever lawyers need to do to properly close a loan.
But
And let me answer one last question for me, and then Judge Bonsford. Do you agree with the AG's amicus brief? Do you agree that that is indeed what lawyers must do?
I agree with part of what the AG says, Your Honor.
Which part don't you agree with?
We don't agree that, for instance, a lawyer must do a title rundown to properly certify title. I think what the AG was trying to say, because the AG also concedes that doing a title rundown is not the practice of law. Non-lawyers can do that work. I think what the AG was trying to say is...
Excuse me, do you mean by title rundown, the last-minute rundown?
Yes, Your Honor, that's what I mean. I think what the AG meant to say was for a lawyer to certify title under Chapter 93, Section 70, he or she must satisfy him or herself that title is still good. We don't quibble with that. We think that's right.
Yeah, but doesn't that extend to the time that the documents are recorded?
It does, Your Honor.
So then a lawyer has to do the update, the title update.
An update needs to be done, Your Honor. Whether or not a lawyer could delegate that process
To
to
a
someone else.
paralegal.
Correct.
But the lawyer is responsible. The lawyer is on the hook
Yes.
for doing that update at the time of the closing.
Yes, Your Honor. And that's a distinction I was drawing. And let me just get back to this one point. What we're saying is the exercise of the practice of law is exercising legal judgment. There is a great deal of steps that are taken in the course of a standard mortgage loan that don't require that level of attention. Filling out forms, getting documents from a municipality to show there are no liens. These are not steps that require lawyers, but there are steps that do.
But even those steps require a lawyer at some point to make sure it is the right form and that it's signed in the
Oh,
right
yes.
place and dated and certified. You can't
Correct.
just have even a paralegal do that, or if you do it at your risk.
That's correct, Your Honor, and we've never contested that. But to the extent that what Enries is doing is collecting documents from third parties, drafting things that are by necessity going to lawyers for closings.
But you say we collect them and we review them. You say that in your brief, and it's the review of them. If you do review them for these issues and for the form to be filled out properly, that sounds like it's exercising legal judgment.
But what I'd submit, Your Honor, is reviewing a document to make sure it's complete and it is not a bad copy is different from a substantive legal review, whether it meets a legal standard.
But I think it was Justice Cordy's question. Where is the relationship between the person or persons who are doing this and the lender or the borrower?
Your Honor,
Or they're all coming through you, right?
No, Your Honor. The record evidence is that the lender gets this lawyer, and beyond that, there's just no evidence that
The lender gets? I thought Enrice has this
Yes.
stable of lawyers.
I'm sorry, Your Honor. Enries engages a lawyer for the lender. What the record is silent about is what happens after that lawyer is appointed. REBA assumes there's no relationship. We can't represent one way or the other because it was never part of discovery.
Would you agree that there needs to be?
Yes, there needs to be a relationship between lawyer and client, Your Honor.
And who should be paying the lawyer?
If it's consistent with 1.8, Your Honor, there's no reason why Enries couldn't pay the
And so
lawyer.
when the client is unhappy, can the client sue the lawyer?
If a client is unhappy about the performance of the lawyer, sure. If it's unhappy about the performance of Enries, Enries could be sued as well.
Well, I'm not sure what your answer is to the question about whether you are selling legal services.
Could I just address that very briefly, Your Honor? I think if you look at McClub and perhaps Thibodeau is the best. Thibodeau was the American Legal Automobile Association. It was an association created to have lawyers represent motorists when they had legal trouble. And what this court said was, it is fine for that organization to find a lawyer and give that lawyer to one of its members and pay that lawyer. What the organization couldn't do is control the relationship. It couldn't tell the lawyer what to do or act as the client, which is consistent with Enries Shue and with McClub. That's all that Enries does. It does get a lawyer. It does engage the lawyer for the lender, but it doesn't expressly doesn't tell the lawyer what to do, doesn't tell the lawyer how to do it, and doesn't get involved in whatever communications exist between lawyer and lender.
Okay, but respectfully, you're also saying the record doesn't allow us to make that finding.
That's correct, Your Honor.
Would you be, what would you think of our saying that on this record we can't decide the question for these specific parties? However, the practice of law in this area would involve blah, 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 and would not involve the other things.
Your Honor, I think clarity is helpful. What we try to do in our brief is illustrate the development of this court's jurisprudence on what the practice of law is. I think the record, candidly, is factually very weak to make factual determinations as to what Enries is actually doing, and I think that is the issue before this court. But the First Circuit asked for your guidance, so I think that would be an appropriate response.
Did you argue to the First Circuit that this was inappropriate for a certified question because
We
the
did.
record had not been developed?
I think that was part of our argument. We certainly opposed certification for a number of reasons, but I think that was one of our arguments, Your Honor.
Thank you, counsel.
Thank you very much.